Welcome back to our channel. For this episode, we are going to learn the fourth article of the 1987 Philippine Constitution, which is all about citizenship. Let's begin by defining the word citizenship. It is a legal relationship between a person and a country. If you are a citizen of a country, you have the right to live there, work, vote, and pay taxes. Moving on to our fan fact for this episode. Did you know that there is a difference between citizenship and nationality? If you are not aware of this, listen carefully. Nationality is simply the country where you came from. For example, Jessie is from the Philippines, so she is considered as a Filipino. It is also important to take note that a person can be a national of one country, but she can also hold citizenship of another country. For example, Katniss was born in the Philippines, but her Filipino parents decided to live in the United States for better opportunities. From this example, we can say that Katniss has a Filipino nationality, but she is also a U.S. citizen, for she is living in the United States and also a legal citizen of that. Now let's discuss the modes in acquiring citizenship. There are two recognized forms in acquiring citizenship: by birth and naturalization. By birth is further subdivided into two ways. First is what we call ius soli. It is a Latin term which means law of the soil. This is a rule that the citizenship of a child is determined by the place of birth. The second one is what we call ius sanguinis. It is a Latin term which means the law of blood. This is a rule that the citizenship is determined by blood relations. The second form of acquiring citizenship is through naturalization. I will discuss this topic later. For now, let's move on to the kinds of Filipino citizens under the Constitution. First, those who are citizens of the Philippines at the time of the adoption of this Constitution. Second, the natural-born citizens. These are the citizens of the Philippines from birth without having to perform any act to acquire or perfect their Philippine citizenship. Now let's answer the question, how can you be a natural-born Filipino citizen? Philippine nationality law is based upon ius sanguinis. Generally, if you are born to at least one parent who is a Filipino citizen at the time of your birth, you are born with a Philippine citizenship. Let's take a look at these examples. First, Zia's mom is a Filipino, and her dad is an American. Is she a natural-born Filipino? You have 5 seconds to answer the question. Your time starts now. Time's up. The answer is a very big yes. Remember the principle of ius sanguinis. If one of your parents is a Filipino, then you are also a natural-born Filipino. Let's move on to our second example. Let's meet Kay. She is an illegitimate child of her Filipino father. Can she be considered as a natural-born Filipino? I will give you another 5 seconds to answer the question. Time's up. The answer is yes. Take note of this. A child born of a Filipino father or Filipino mother, whether the child is legitimate or illegitimate, is still a natural-born Filipino. For our last example, let's call Laika. She was born in America, but her parents are Filipinos. Is she a natural-born Filipino? I will give you another 5 seconds to answer the question. Time's up. The answer is yes. If the child is born in another country, but her parents are Filipinos, she will still be considered as a natural-born Filipino. In the case of Laika, she is qualified for dual citizenship. I will discuss this topic later. The third kind of citizens under the 1987 Philippine Constitution are the citizens through election. These are the people born before January 17, 1973 of Filipino mothers who elect Philippine citizenship upon reaching the age of majority. Under the 1935 Constitution, the child whose mother was married to a foreigner was born an alien and remains an alien until he elects Philippine citizenship after reaching the age of majority. This rule was changed. Under the 1987 Philippine Constitution, a Filipina does not lose her citizenship by her marriage to an alien. Last are the naturalized citizens. Aliens or foreigners can become Filipino citizens through naturalization, or the process of allowing a foreigner who lives in one country to become a citizen of another country. However, they must first renounce their original citizenship before they become naturalized Filipinos. There are three ways in order for aliens to become naturalized citizens of the country. First is the direct naturalization. This is further subdivided into three ways: administrative naturalization, judicial naturalization, and direct act of the Congress. Let's discuss administrative naturalization. This applies to native-born aliens who lived in the Philippines all their lives, who never saw any country and thought they were Filipinos. This follows Republic Act 9139, or the Administrative Naturalization Law of 2000. Here are the qualifications. First, must be at least 18 years old. Second, must be born and have lived in the Philippines. Third, must have good moral character and must believe in the Constitution. Fourth, must own a real estate in the Philippines for not less than 5,000 pesos or have some lucrative trade, profession, and lawful occupation. Fifth, must be able to speak and write in any Filipino dialect. Last, the minor children of school age must be enrolled in the schools prescribed by the law. The second way is the judicial naturalization. If a foreigner is not qualified for administrative naturalization, then he will have to go through judicial naturalization, which follows Commonwealth Act 473 or the revised naturalization law. Here are the qualifications. First, must be at least 21 years old at the hearing of the petition. Second, must reside in the Philippines for at least 10 years. Third, must have good moral character and must believe in the Constitution. Fourth, must own a real estate in the Philippines for not less than 5,000 pesos or have some lucrative trade, profession, and lawful occupations. Fifth, must be able to speak and write in English or Spanish and any one of the principal Philippine languages. Last, the minor children of school age must be enrolled in the schools prescribed by the law. The last way, under direct naturalization, is through a direct act of the Congress. Legislative naturalization is quite rare, and this applies only for aliens who have made outstanding contributions to the country. The second way of becoming a naturalized citizen is through derivative naturalization. Derivative citizenship is defined as obtaining one's citizenship from or through another person. You can be any of the following: wife of naturalized husband, alien wife of a natural-born citizen, or a minor children of naturalized parents. It is also important to take note that naturalized citizens cannot enjoy the following. First, dual citizenship. Second, run in any political position. Let's move on to the effects of marriage to a foreigner. Citizens of the Philippines who marry aliens shall retain their citizenship unless they renounce it. Now let's talk about the loss of citizenship. Filipino citizenship is not forever. Filipinos may lose citizenship voluntarily and involuntarily. First is voluntarily, or also called as expatriation. It is a process of leaving your country and living in a new one. It may be through naturalization in a foreign country, renunciation of citizenship, subscribing to an oath of allegiance to support the Constitution or the laws of a foreign country. The second one is involuntarily. These are the following ways where you can involuntarily lose your Filipino citizenship. First, cancellation of certificate of naturalization by the court. And second, if you are a deserter of the Philippine Armed Forces. Next, reacquisition of lost Philippine citizenship. Citizenship may be reacquired. Here are the several ways of reacquiring citizenship. First, naturalization. Second, direct act of the Congress. Third, repatriation, or the recovery of original citizenship. This is made by making an allegiance to the Republic of the Philippines. For our last topic, let's talk about dual citizenship versus dual allegiance. Many people are confused between dual citizenship and dual allegiance. Let's define these two terms. Dual citizenship means you are a citizen of two countries at the same time. For example, a child born in the United States with Filipino parents can have a dual citizenship because United States follows Jus Soli, and his parents are also Filipinos, where Jus Sanguinis is followed. The child is legally both a Filipino and an American. On the other hand, dual allegiance refers to the situation in which a person simultaneously owes loyalty to two or more states. What the Constitution prohibits is dual allegiance, not dual citizenship. That's all for this episode. Be sure to like and subscribe to our channel because more incredible videos are on the way. Also, if you have friends, share this video. Thank you for watching.